So, welcome everyone. My name is Jay Hedges. I'm a third year student here at St. John's University School of Law, and I serve as the Research and Symposium Director of the Journal for Civil Rights and Economic Development. We're really glad that you've joined us for this symposium panel, Racial Capitalism as Legal Analysis. I want to begin this morning with a brief comment about our journal and the background of the journal, as well as some context for today's topic. Before we start, though, I think it's important to acknowledge and tribute the indigenous land in which St. John's University is located, land of the Lenape, Canarsie, and Matininac people. In 2010, what had been the Journal of Legal Commentary was renamed the Journal of Civil Rights and Economic Development, or JCRED, to reflect its status as the official publication of the Ron Brown Center for Civil Rights here at the law school. From then on, the journal has been dedicated to exploring issues of social, racial, and economic justice in the law. And I think what's important about JCRED is that it is situated to be a publication which breaches the divide in legal academia that has held so much power over legal scholarship over the years. And that's a segregation between issues of public law and private law. The realm of public law being considered the only appropriate space to discuss issues of identity-based oppression covered in civil rights cases and anti-discrimination litigation of constitutional law. The realm of private law, on the other hand, being the neutral economic space, devoid of any considerations of identity or historical context, where the law of contracts, business organizations, and property traditionally exist. And never the twain shall meet. There's no doubt that this arbitrary divide has been a major disservice to legal scholarship. And that's why I think the most important word in our journal's title is the connector and civil rights and economic development. This makes us uniquely positioned to disrespect the divide, promoting scholarship which recognizes that racial justice and economic justice go hand in hand. You can't have one without the other. And thus, one cannot grasp the full picture of the legal dynamics of any given social problem unless you bring both considerations to bear. And that brings us to today's topic, racial capitalism as legal analysis. I won't venture to give a singular definition of racial capitalism. Maybe our panelists will give you theirs. It's a necessarily expansive concept. I do want to draw out relevant aspects of racial capitalism as a foundation for our conversation today. And this is where the works of Professors Athena Matua and Carmen Gonzalez have been vital in mapping racial capitalism. They point out that racial capitalism is a global system characterized by exploitation, both of waged labor and often the unpaid or underpaid labor performed primarily by women, expropriation or the confiscation of human, non-human, or natural resources without a fair exchange of value, and race making, the creation of social hierarchies among humans, and the assignment of superior or inferior status based on specific characteristics. Key to racial capitalism is that these processes are carried out in the service of wealth accumulation and white supremacy. And important to recognize for our conversation today is that the processes of racial capitalism, exploitation, expropriation, colonization, racialization, these are all rooted in legal systems and enforced, often brutally, through legal mechanisms. Think, for instance, of the topics which I'm sure our panelists will touch on today: foreclosure, eviction, gentrification, water shutoffs, water debt, police brutality. These are forms of racialized violence that are carried out or legitimated by legal mechanisms. Racial capitalism, though, while it's been explored in much more depth and for a longer time in the disciplines of history and sociology, it's only recently been explored in legal scholarship. Uh, we are fortunately among a group of journals which are now publishing on this previously underexplored concept in the law. And this is actually, as far as I'm aware, the third such panel on racial capitalism in the law just this month. Um, we're proud to join this conversation through the incredible work of these three panelists. Um, so the way today will proceed, we will have brief presentations from each of the panelists about articles that are relevant to the topic, followed by a moderated discussion, and then plenty of time for question and answer from the audience. Um, for questions, feel free to put them in the chat. We would also like for you, once we have the specified question and answer time, for you to unmute yourself if you're comfortable, put yourself on camera and ask the question yourself rather than me rephrasing what you may have written in the chat. But feel free to also put thoughts or comments in the chat. So without further ado, our panelists today are Chaumtoli Huck, Associate Professor of Law at CUNY, Marissa Jackson-So, incoming Assistant Professor here at St. John's Law, which we are very excited about, and John Whitlow, Associate Professor at CUNY Law. We will first hear from Professor Huck about her article, Integrating a Racial Capitalism Framework into First-Year Contracts, a Pathway to Anti-Capitalist Lawyering.
Great. Will you give me like 2 minutes? Yeah, just because I want to make sure that we give time for questions. So first of all, thank you so much, Jay, and to the editors of JCRED for putting together this symposium. As you mentioned, this is a topic that has been around for a while, but has been sort of newly discovered within legal academy. And to have St. John sort of be in the sort of forefront of that is very exciting. I see a number of familiar faces and names. And so, yeah, and so I won't shout out indelicately, but thank you all for being here this morning. So I'm going to start with a quote by Angela Harris, who wrote a foreword to Histories of Racial Capitalism, which is a recent publication that I think sums up my essay. I think she does it beautifully, but I'll still keep my 10 minutes of comments. Racial capitalism that engages with the law helps advocates dream into being new forms of governance. And so in many ways, my essay, by engaging with the contracts, the law of contracts, seeks to do precisely that. Contracts, as you know, is a mandatory foundational course for all law students. And by engaging racial capitalism with the doctrine of contracts, I hope that it provides students a pathway to public interest lawyering. And I guess I would go a little bit bolder to say anti-capitalist lawyering. And I'm actually borrowing the definition of anti-capitalism from Professor Matua regarding how the market redistributes and allocates resources for the material conditions of life. So I won't go too much into that definition, it's in the paper. So in my brief time, what I wanted to do is just reference what I mean by racial capitalism. As Jay mentioned, this is a term that is contested and being elaborated. And there are different sort of intellectual strands that I think we need to sort of pull together as we're talking about racial capitalism. And then I'll just very quickly sort of highlight some of the key points that I make in the essay. And I hope that that would then sort of generate some discussion. So racial, and I'll be periodically looking down, so I apologize for that. So racial capitalism can be described as the mutual interdependence of racism and capitalism, a form of capitalism that relies on and is maintained by the exploitation and reproduction of racial differences. It functions precisely by assigning measurable benefits based on race. And in this respect, law is definitely implicated in that function. Scholar Ruth Wilson Gilmore oft cited quote sums it well. Capitalism requires inequality and racism enshrines it. Perhaps scholar Cedric Robinson most popularized the concept of racial capitalism in his book, Black Marxism, which actually was just recently republished with the foreword with Robin Kelly. But I think I want to draw from scholar Charisse Burden-Stelly, who discusses in her piece, Modern U.S. Racial Capitalism, that actually many Black anti-capitalist thinkers of his time articulated this view from South African scholars and a lot of anti-colonial scholars. So in this way, racial capitalism is, while being discussed in the context of the United States, is very much also an anti-imperial and anti-colonial theoretical perspectives. A foremother or thinker of racial capitalism that often gets ignored is Claudia Jones. Claudia Jones is a Trinidadian Black communist feminist from Harlem. She discusses the intersection of capitalism, feminism, and racism. So Burden-Stelly sort of defines racial capitalism broadly as a racially hierarchical political economy constituting war and militarism, imperialism, and expropriation, a lot of what Jay sort of defined earlier. But I want to also say, in light of the history of Claudia Jones and the Combahee River Collective, that racial capitalism is ultimately a Black feminist enterprise and political project, and that of scholars of the Global South. So any anti-racist project must, at its core, be feminist. And this response to questions I often get as a woman of color is, what about gender? You're always talking about race. And here I want to sort of invoke Chandra Mohanty's concept of a transnational praxis, where she talks about to be feminist is to be anti-capitalist and to be anti-racist. That when I'm talking about anti-racism or racial capitalism, I'm also inherently talking about feminism. So in invoking racial capitalism, I'm really bringing into the fold these multiple formulations and contestations, and in its present iterations of racial capitalism. And I think this journal and the scholarship, kind of continues that. One of the things I think is really important to note is that racial capitalism is a movement-oriented theoretical perspective. When Cedric Robinson was writing Black Marxism, was very much deeply involved in Black radical movements. Many of the scholars who have been engaging with racial capitalism have also been engaged in movement work. So for me, racial capitalism is also a theoretical praxis, in the sense that it's not something just for us as academics to, sort of ponder on, but it's actually something that gives us some insight into activism, and I would say in this case, lawyering. In the legal academy, I think Jay has already mentioned that critical race theory hasn't sufficiently engaged with the topic of racial capitalism, although I think with Angela Harris's forward, we will see more of that engagement. I think that CRT scholar Cheryl Harris in Whiteness and Property, although doesn't explicitly mention racial capitalism, in essence describes the way in which law is implicated in the reproduction of racism and inequality. This idea that whiteness has its own social identity and value. Professor Jackson Stowe's work on whiteness as contract, I think, really develops that scholarship further. So it's important to, again, stress that both CRT, critical race theory, and racial capitalism, both while originating as by academics and in the academy, is ultimately a movement theoretical approach. So in the essay, I tried to make sort of 3 key points about why racial capitalism is important to the study of contracts and for first-year students. And I do this essentially, and the paper kind of goes into detail, and so I'm going to probably just give you the highlights of those points in the interest of time. I think one of the things is that the racial capitalism provides a critical analytic lens to the study of contracts, allowing students to challenge its epistemology, its foundation, its core that we take for granted. Some of the concepts of neutrality, objectivity, and universalism that get sort of presented as normalized particularly through neoclassical economic theory, racial capitalism serves to counteract that. It illuminates the way that law and market structures maintain racial subordination. And I think, and then finally, it reveals limits of equitable contracts. You know, one of the areas as contracts professors, we think that equitable theories like restitution or promissory estoppel is going to sort of solve the deficiencies of contract. That's the place where justice sort of parks itself. And I think racial capitalism upends that idea and shows the limits of racial shows the limits of those equitable theories. Let's see, how am I doing on time?
About 2 more minutes, two and a half more minutes.
Yeah. So, so in the piece, I deconstruct Kirksey, which is a kind of foundational case that most law students read. I won't go into the specifics of that, but Kirksey is presented as a private dispute between two parties, a brother-in-law inviting a sister-in-law to come stay and move into the land. But when we look a little bit closer into the case, we see that the brother-in-law and the sister-in-law are essentially using contract doctrine as a way to manipulate land schemes at the time that exclude Native Americans and Blacks from accumulation of land at that time. Also, a violent exclusion of Blacks. As you remember, most of land loss that occur in the United States is through lynching and violence, and both a lot of wealth theft that occurred in Black communities that sort of to this day is because of that. So Kirksey, I sort of uncovered the case to provide that context and to sort of show that it's really not sort of this private dispute between two parties that have no context whatsoever in terms of maintaining racial subordination. The ability to promise, the right to even promise, is predicated on white supremacy, right? So Kirksey's ability to promise his sister-in-law to come and live on the land is based on his entitlement as through whiteness and being able to even obtain the land. The second two examples, I'm going to just kind of go through quickly because in the interest of time, is I use an example of an appraisal where a biracial family, when it was known that the owner was a Black woman, the appraisal was 40% less. When the white husband then re-put the house on the market, the value went up. I think this is a very excellent example for students to show that there's something else that's operating, and where I suggest what's operating is what Harris describes as whiteness as property, that whiteness has a value. And so whether Black homeowners as buyers and as sellers, in both instances, because of race, lose the value of their capital. And I'm not to suggest Black ownership, or I'm not suggesting Black capitalism here, but to show actually that the market is ultimately unfair, and that the solutions to redress that are not simply just to give individuals access to the market, right? And then the last point that I make an example is talking about how racial capitalism shows the elusiveness of reparations. We have been for years trying to get a study in reparations, let alone reparations alone. But reparations to me is a quintessential restitution concept that has been enshrined in contract law, that one who provides labor should be compensated for that. And so it's been documented in terms of the historically and to the present, the ways in which wealth and labor has been extracted from those who are experience racism and formerly enslaved. Yet reparations remains elusive. And so my point there is that when we look at racial capitalism and restitution, we actually see why reparations is elusive, because ultimately it's a critique of capitalism. The reparations movement will only be successful if we're willing to have a wholesale redistribution and reorientation of the economy. And without a substantial shift in the economy, we're not going to really see that. The last point I wanted to make, just referencing Robinson and Du Bois, that reparations, while presented as a political concept, is ultimately has an economic dimension. And so unless we really are willing to tackle that, we're not going to see that as being successful. So I'll end there just because I know I'm out of time. And hopefully we'll be able to talk about what does this mean in terms of anti-capitalist lawyering or lawyering strategies. What does it mean for our students? So thank you.
Thank you, Professor Huck. And yes, we should definitely get into that in our discussion following. Next, we will have Professor Jackson So present her paper, which is forthcoming in Washington and Lee's Law Review, Whiteness as Contract, and also point out that she has recently also kind of put online to be reviewed in a forthcoming publication her article, Rebuilding the Master's House, Dismantling America's Colonial Politics of Extraction and Exclusion. So we're excited for the presentation. Professor Jackson, so I'll put in the chat, or I'll say out loud a 2-minute warning and then put in the chat when you're close to time.
Thank you so much, Jay. Thank you, everyone, for being here this morning. It's an honor to be able to join you even before I, sort of join you formally, and it's an equal honor to share this morning with Professors Huck and Whitlow. I have looked up to, and I've been in conversation with Professor Huck specifically, and to find out that we are, co-panelists and also going to be teaching contracts together is very inspiring indeed. And so, what I will try to do in the brief time that we have is talk a little bit about whiteness as contract, but then I'll also talk about how whiteness as contract feeds into the forthcoming paper, Rebuilding the Master's House, which was mentioned. So Whiteness as Contract is actually the second installation in a series of papers. The first is coming out in a couple of weeks that deals with the Detroit water shutoff crisis squarely. And I have been studying the water crisis, the water scandal. I don't call it a crisis because crisis implies that there was something that nothing could there was something that happened that nothing could be done about, whereas this was a function of law and government policy. And so I have been following the water scandal for since its inception, right? And I actually was living in Detroit and clerking at the time that the shutoffs began. I'm actually I'm a native of Detroit, grew up in Detroit. While I was clerking, a fellow clerk of mine, who is a dear friend, told me something that has guided my scholarly inquiry ever since. She said to me, when something doesn't make sense, follow the money. So for me, that was transformative because the shutoffs were beginning in Detroit, and for the life of me, I couldn't understand why. Like, why was this a solution to Detroit's revenue woes? At the time, I considered myself, I still do, considered myself squarely within the discipline of human rights law, and secondarily, as sort of a civil rights lawyer. I had not yet sort of thought of my legal inquiry into this matter as in terms of racial capitalism, right? I was looking at it as a human rights violation, and I couldn't understand, the UN has come to Detroit, the UN has condemned Detroit. Why isn't that enough for the government to say, we're embarrassed. This is not where we want to be. I realized that human and civil rights are not really matters of morality as pertains to race, right? And I think that's important because human rights are often imagined as, right, or often presented as, right, moral arguments, right? They're values that we all have inside of us as humans that we are bound to respect. But with respect to race, right, as I sort of began to study modern racial formation and settler colonialism as a global project, I realized that human rights actually are more related to power than morality, right? And that the moral arguments only seem to work when you're dealing with the rights of white people vis-a-vis other white people. So then I was led to wonder, well, why and how could that be? So when I talk about whiteness as contract and then go to talking about the rebuilding the master's house, what I'm actually trying to do is sort of tracing a path, from power, how power then became transformed into a narrative around morality, right? How we can deconstruct that, and really talk more about the foundational elements of brutality and extraction that have fundamentally informed the American project, and then what we might do about it to actually get us back to the sort of espoused values of human rights that we purport, but have been betraying for centuries at this point. So I started my paper series discussing Charles Mills's theory of the racial contract. And then I got to whiteness as contract as a theory by essentially merging Mills's theory with Cheryl Harris's theory, right? And I sort of tried to bake it up, and the bread that I got was whiteness as contract as a theory. Professor Harris does, did an incredible job of describing the what's of whiteness, right? As Professor Huck has outlined for us this morning. What whiteness as contract attempts to do is to explain the whys and the hows of whiteness, right? By redefining whiteness as property as something for which people continuously bargain, insofar as they are the beneficiaries thereof. The architects of white supremacy could be understood as the signatories to that contract. So therefore, you have a system in which you have some people, many people who are signatories are actually perpetuating white supremacy as economics, as politics, right? We've been in that mode in the United States for the last sort of several years, right, under the last administration, where whiteness was actually promoted, right, as an economic engine, as political weaponry. And then you have those who simply benefit from whiteness, right? It's casually, as a matter of status quo, as a matter of unchecked privilege, right? I actually think that the people who are beneficiaries and not signatories can actually do more damage and can actually perpetuate racial capitalism more easily, because there is that blurring of intent, right? We're not actively racist. We are just sort of going about our business and perpetuating these systems and benefiting from these structures day after day. How many of us, right? How many of us wake up in the morning and say, wow, the United States has colonies. The United States actually is still a colonial empire with colonial subjects. None of us, right? And so what that means is, even I, as a person of color, as a Black woman, who wakes up and sort of goes about her business with little thought, typically, to the fact that Guam, that the U.S. Virgin Islands, that the District of Columbia has no political representation, and yet we continue to govern them, to rule over these territories and their people, that we continue to extract resources, right, regularly, and that those resources fuel our economy, that they actually fuel our governance, right? We all remember Donald Trump's second impeachment trial and the magisterial management of that by Delegate Stacey Plaskett. She cannot vote for president. Her constituents cannot vote for president, right? And so she was able to invest labor into a polity that has structurally and legally and permanently so excluded her from participation in the social contract. Whiteness, I define as a system of separate yet interrelated, coordinated commercial contracts and social contracts. The commercial contracts are those formal sort of business deals, right? They're obviously legally enforceable. The social contracts are tacit. They may not be expressly enforceable, but they are given force through law. Now, in whiteness as contract, I support that theory using 3 case studies: the Detroit water scandal, the Flint water scandal, and a case called Comcast versus National Association of African American Media. Today, I will briefly add on 2 more examples. I'll add on the opinion in Dred Scott, where Justice Taney sort of lays forth over 200 pages the United States divine ordination as a global superpower, as a colonial state, and talks very specifically about why we do not allow Black people to become citizens of the United States. And he also goes into a discussion of why we did not allow at that time interracial marriage. He defines interracial marriage as a contract, a legally enforceable contract that would undermine the social contract of whiteness, that in his view, there was an interest in protecting, right? And he used it as an example of why we did not at that time allow Black people entry into the social contract. And so you have an example of the relationship, right? This fundamental relationship that exists between those obvious formal contracts and this tacit, invisible, but equally powerful social contracting that happens. The second
In
case
2
study
minutes,
that I want,
Professor Jackson, so just so you know.
of course, thank you. The second case study that I will add to that is found in Professor Terry McMurtry Chubb's forthcoming book, Race Unequals, where she describes overseers' employment contracts on, obviously, right, their jobs were to manage plantations, manage slaves, slave labor, slave output. And she makes this really compelling case for how the overseers' employment contracts enforced and enshrined their status as men and as white people, but also because these were employment contracts and because the planters could take them to court and sue them for sort of loss of slave life and labor, also could place constraints on their whiteness, the level of their whiteness and the level of their masculinity. And so that again is a really palpable example of how formal employment commercial contracts actually give force, right? Actually give force to the social contract of whiteness, which perpetuates capitalism in the United States and allows it to sort of be, sustainable for years and years and years, right? Centuries to come. I'll briefly touch on for the next 30 seconds the Comcast case and why it's important, right? Byron Allen sues Comcast because under the Civil Rights Act of 1866, which for the first time and like one of the few times in the Constitution mentions whiteness. It says people of color will have the right to contract that is enjoyed by white citizens, right? This is after slavery. He loses at the Supreme Court. Why does he lose? Because the Supreme Court says that even though race was clearly a motivating factor in why Comcast would continue to court him for years and years and years and refuse to engage in any business deal with him because his programming appealed to Black audiences, that race had to be more than a motivating factor. This is important because it shows that, even where there are rights enshrined in formal law, there's often for Black people an inability to avail themselves of those rights, and beyond that, an inability to avail themselves of remedies even when the right has been clearly violated. In closing, I will say, I talk in Rebuilding the Master's House about what we might do once we realize what we're actually dealing with. Once we realize that the House, the United States, is built on poor foundation, with rotten materials, and with slave labor, what we might do to transcend, sort of dispense of racial capitalism and move beyond racial capitalism towards something approaching justice. And so I sort of advocate for, in the first instance, right, allowing these colonies to decide for themselves whether they would like to remain colonies, whether they would like to become states. Of course, pushing for DC statehood, but certainly also, as Professor Huck said earlier, having a really serious conversation about what reparations would look like, and considering that they are absolutely necessary once we are willing to confront the fact that we are actually still a colonial empire, and that we still rely on the extraction and the brutality that comes with that extraction, even in 2021. So with that, I will yield my time and thank you again for allowing me to present this morning.
Thank you, Professor. That was excellent. And now we will have Professor Whitlow presenting on his article, The Real Estate State and Group Differentiated Vulnerability to Premature Death, Race, Class, Geography, and Pandemic. So take it away, Professor Wetlow.
I've never been good with titles. Every title I come up with is just extremely clunky. First, I want to thank the good people at JCRED for putting together this symposium, and also just say that I'm completely honored to be presenting alongside my co-panelists, who are extremely tough acts to follow. So, as Jay mentioned, my paper, it takes a little bit of a different tack to this problem or problematic of racial capitalism. It looks at the racialized and deadly unevenness of COVID-19's spread in New York City last spring. And I actually want to start on a little bit of a personal note. Last March, with COVID bearing down on the city, I decided to leave with my family and go down to North Carolina and weather the storm. And it was a little bit of a Gilligan's Island situation. I somehow thought it would be like a 2-week stay, and it ended up being a months-long stay. And from our readout in North Carolina, we were able to work remotely and order all of our necessary and unnecessary supplies. And of course, maybe I shouldn't say of course, and continue to have access to healthcare. And we also followed the news of what was unfolding in New York City. And I remember one event in particular that was very searing, which was reading from North Carolina about a candlelight vigil held in Corona, Queens, to honor 67 members of Make the Road New York, an organization that's near and dear to my heart, who lost their lives due to the coronavirus. And for those of you who don't know, Make the Road is a membership organization comprised of working class immigrants from all over Latin America who work primarily, I think, in the construction and the service industries. And I worked as a staff attorney there years ago now. But there's something pretty devastating about just reading about people's lives cut short because they didn't have really the luxuries that my family and I had in terms of working remotely and the sort of things that I briefly laid out. And that shot me directly into two quotes that I want to lay on you and kind of underscore and ask that you think about as I continue with my remarks. The first is a quote from Ruth Wilson Gilmore, who Professor Huck mentioned. She's a critical geographer and abolitionist and a mentor of mine. And the quote is this: "Racism is the state-sanctioned or extra-legal production and exploitation of group-differentiated vulnerability to premature death." The second quote is from the poet Octavio Paz, who I think, this is no disrespect to Ruth Wilson Gilmore, but kind of conveys the same meaning much more succinctly. He says, "Tell me how you die, and I will tell you who you are." In case anyone was wondering, this is not going to be the most uplifting talk. Lots of death in this talk. So I wanted to really explore in this paper these themes of who gets to live and who dies early in this system we live in, and how this is structured by race and racism and by law and policy. And more specifically, I wanted to better understand the structural forces underpinning the racially uneven deadliness of COVID in New York City last spring. And this task seemed to require an analysis that focused on how inequality is produced and unfolds along vectors of race, class, and geography. So with my remaining time, I'm just going to talk a little bit about how I put all of this together in this paper. I relied on two main theoretical concepts, racial capitalism and law and political economy. And I fear that my description of racial capitalism is going to be a bit redundant because my two co-panelists did such a great job of kind of laying it out. But I'm basically using it to explore how capital accumulation depends on and produces racial differentiation, subjecting racialized groups of people to disproportionate vulnerability to premature death, as I've said. And the idea here is that capitalism is and always has been a system based in exploitation and the production of inequality. And the function of race within that system is to naturalize and in so doing legitimate that inequality. The implications of the analytical framework of racial capitalism, I think, are powerful and also politically challenging. Capitalism produces, in fact, requires inequality, but that doesn't organically lead to a neat political divide between the haves and have-nots. In fact, quite the contrary. The process through which capital accumulates has historically seized on all manner of human differences, which are often accounted for and naturalized through racial categorization. This has a legitimating and reproductive effect on the social order, cementing as normal and unchanging inequalities that are in fact socially produced and dynamic. In this process, the extraction of value from a racially segmented working class is intensified, with benefits concentrated ever more in the hands of the few. And I'll just note that I think there's a really important subjective dimension to this. The Jamaican-born British intellectual Stuart Hall noted famously that race is the modality through which class is lived, which I think is a really rich quote, and I'll leave you with it and move off of it because there's sort of too much to unpack there almost. If racial capitalism is a theoretical perspective centered on the relation of racial thinking and practice to the inequalities produced by capitalism, then law and political economy is a framework that focuses on how these inequalities are legally constituted. Law and political economy starts from the premise that law has played a central role in the creation of the various and interlocking crises we currently face, conditioning race and wealth, social reproduction, and environmental destruction. And it follows from this starting point that law also necessarily conditions political responses to the existing order and will play an integral role in the construction of a more just, equal, and democratic society. So armed with those theoretical tools, again, I wanted to look at COVID's unequal, racialized deadliness last spring in New York City, and to look at it through the prism of land, real estate, and housing policy in the city. And I'll just lay out some key moments in the story. I also should note that I think there are many different ways to tell this story. I mean, I think if you wanted to focus on, COVID spread through our prison system or, the nursing home context, I actually think that you would have much the same analysis, but the sort of key moments in the telling of the story would obviously be different. So just, in the interest of time, I'll try to just highlight some of what I touch on in the article. And the first point is to note that the fiscal crisis that New York City underwent in the 1970s led to a dramatic restructuring of the city's political economy along neoliberal lines, favoring finance capital and real estate over labor and other subaltern groups. In the crisis and post-crisis years, working class Black and Latino neighborhoods were subjected to austerity and disinvestment and were essentially abandoned in an organized way, to use another Ruth Wilson Gilmore kind of analytical tool. And these neighborhoods were essentially devalorized in the process. We've probably all seen images of, the Bronx burning, and we know about the phenomenon of landlords abandoning properties because it was actually more profitable to do that in some instances, than to maintain them, which is just a crazy, crazy thing to even think about in the context of our current real estate market in New York. And market-based housing policy in the post-crisis decades resulted in the gutting of rent regulation and housing code enforcement, and the coming to prominence of zoning and tax policies that operated to marshal private capital into many of the same parts of the city that were previously abandoned and devalorized. The result of all of this has been the construction of a highly unequal, gentrified city in which precarious workers with precarity organized along racially hierarchized lines, living amid poor housing conditions dealing with meager services, high rent burdens, and often having to crowd into apartments because the rent is so high. Against that political, economic, and spatial backdrop, it's no surprise that the neighborhoods of the city's Black, brown, and immigrant working class, Corona, parts of the Bronx, suffered disproportionately last spring as COVID hit the city, while unsurprisingly, whiter, wealthier parts of the city did not. In other words,
Professor Whitlow.
Thank you. I've only got 15 more minutes to go, so I'll try to condense that. In other words, I'm laying much of the blame for the racially disparate deadliness of COVID in New York City last spring on decades of racial neoliberalism that has been driven largely by the political and economic power of the real estate industry. And because I want to end on an optimistic note, in the last part of the article, I discuss possibilities for a politics beyond racial neoliberalism. And here I focus on a number of recent mobilizations in New York City that I think offer examples of workers and tenants coming together across traditional lines of difference to fight for a different kind of society. In particular, I focus on mobilizations to strengthen the rent laws. This occurred in 2019, and the effort to defeat Amazon's relocation to Queens, both as examples, again, of the capacity of people to combine their energies and to fight against market-mediated and racialized inequalities. And, you know, returning to the two quotes I highlighted earlier, the Gilmore quote and the Paz quote, both of which, you know, I think explicitly have to do with death. You know, these mobilizations offer hope for the creation of a society in which life is viewed as unqualifiedly precious and in which the inevitability of death encloses on us all equally. I'm not sure if that's a high note to end on. But it's a note. So thank you all, and I look forward to talking with you more about my article.
Great, thank you, Professor. Let me make sure that I don't have a timer go off in the middle of unmuted. Thank you, each of you. This was really helpful and a great insight into the work that y'all have labored on and the scholarship that y'all are bringing out. So I do want to, you know, kind of try to have a conversation about points of convergence where each of your articles touch on maybe a similar topic, and you all can chime in on distinctions or dig deeper into how those concepts play out in your work. And I also want to give maybe a warning or just a heads up for our audience to start formulating questions. Think about what you would want to ask. Feel free to start putting things in the chat as well as we are talking. Know that we will move to like a formal Q&A and really ask that you'd join in with us and kind of dig deeper into this conversation. So one of the first things, each of your articles deal with theory in some way. And Professor Huck mentioned this explicitly of the connection between theory and praxis, or how we connect these legal theories to actions on the ground. So I'm wondering if you would, each of you kind of discuss what are the theories underlying your work, and how do you think, or why do you think it's important to formulate a theory when you're approaching legal scholarship? You know, I think theory is something that maybe students or professors even think is an unnecessary thing to bring into legal analysis and legal doctrine. But others of us are really thirsting for the context that theory provides. We'd like to hear from whomever would like to chime in on the theory behind their work.
I'll jump in. I'll say that anybody who doesn't like theory is going to be really, really, really annoyed by me as a professor, because theory is really what I do. I think it's important because it, there's a lot of theory already out there, right? And so what I consider myself a deconstructivist, right? There's a lot of talk right now about whether we're going to have a third Reconstruction. I don't know whether that's wise because the first two didn't go very well, but if we're going to do that, if we're going to do that, you have to deconstruct the faulty construction properly before you can actually reconstruct, right? Sometimes a paint job won't do. Sometimes it's not just new windows. You have to really take out the entire foundation and make sure you're not on quicksand in the first place. And so for me, it's really important, like whether I'm teaching contracts, property, or even, right, the human rights law or civil rights law, to help people question the assumptions that are already baked into those laws, because I think the three, the presentations you've heard this morning really address rather squarely the fact that law has been instrumental, right? That racial capitalism could not function, could not operate without law, without government, without policy, and so, if neoliberal theory has gotten us to where we are today, where people are literally dying because of the combination of climate change and this era of pandemic that we're in, combined with decades of disinvestment and extraction that is racist and colonial, then we do need to have theory that will help us to see that, right? It's easy to not see all of this because it's just normalized, because whiteness has become an arbiter of value. It is the norm. If we are not able to see the impacts, right? The impacts that whiteness as a structure, right? I'm not talking about people. I'm talking whiteness as a structure. If we're not able to see the impact of whiteness upon those who live in the space of non-whiteness, then we can only hope as lawyers and legal scholars to perpetuate the same inequalities and to perpetuate the same politics of death that Professor Ritlow just talked about. So for me, theory is crucial. I will be offering a lot of it, and I hope that will be okay.
Maybe I can jump in here. I mean, I think for me, theory ultimately is one's way of making meaning of the world. And so that if theory is located in the point of view of the marginalized and those who are from the community, I think that if we're committed to social justice, then we have to engage in the ways in which communities are making meaning of their world, right? I think that there's ways in which in the academy, theory is presented as an elite enterprise. And so not to toss in another theoretician, but I'm very much influenced by Gramsci, who talks about all of us are theoreticians. Recently, this past week, I lost my grandmother. My grandmother is a theoretician, right? And so I locate theory in traditions that are about movement and social change. So I do make a distinction between which theoreticians I'm sort of like referencing, which intellectual threads that I'm actually carrying on and carrying forward, because I think that it does make a difference. And to say that law does not present a theory, in contracts, law presents a neoclassical economic theory very much clearly. It espouses a particular value. So one of the things I do in my paper is to say that sometimes we're accused, particularly who might sort of tilt a little bit to the left, is indoctrinating our students. But in fact, what I say is that by not providing counter theories or different insights into how we understand the law, we're actually assimilating our students into one theoretical perspective, which in contracts is a neoclassical perspective, neoliberalism. We're actually not doing our students justice. We're not providing pluralism and a democratic education. So for me, it's like, that's how I look at theory in terms of it's really about how do we make a meaning. And so the scholars I look towards, I mentioned, are going to be scholars who are very much deeply rooted in the movement work, who have this sort of a connection to movement work. And I hope I'm just a new newbie to this profession as an academic, I hope to sort of be part of that. And like Professor, so if you're a student in my class, you're also going to get critical legal theory. I think it's essential for social justice lawyers. The last thing I just want to say, I actually start my paper with a quote from Bell Hooks, who is another person who I think informs very much a part of this and pushes back on this sort of anti-theory, right? Because if you think about the long tradition of global South scholars and Black feminist scholars have always engaged with theory. If you eliminate theory from our ability to make meaning, ultimately you are denying the opportunity of a people to make meaning of their lives and for liberation. So to me, I'm suspicious of anyone who tries to deny me the ability to engage in theory, because ultimately I think it's anti-liberation project. So just I'm going to end with this quote. I came to theory because I was hurting. The pain within me was so intense that I could not go on living. I came to theory desperate, wanting to comprehend, to grasp what was happening around and within me. Most importantly, I wanted to make the hurt go away. I saw in theory a location for healing. That's from Teaching to Transgress.
Yeah, it's a blessing. It's a blessing and a curse to go last here. I don't know that I have a whole lot to add. I mean, I would just say, and I think it's probably more complimentary than new vis-a-vis what's already been said. That I think theory it helps. It helps you in the sort of old, according to the old Marxist quote. It helps you to interpret the world. But the point really is to change the world. And I think the challenge is, one could find themselves as sort of in the position of sort of armchair theorists. And I think one of the really cool things about this panel is I think we're all trying to articulate theory to practice in a way that really does, intervene meaningfully in these hierarchies that I think we're all deeply invested in dismantling.
Thank you all. I do want to, I've got a million topics that we could discuss, but before we go any further to that, I would love if students have questions, if you would go ahead and unmute yourself and ask. You could ask either specifically about any of the panelists' presentation or generally to each of the panelists, but want to open us up to that. And Jaleesa, I see you with your hand raised. Go ahead.
Hello, everyone. I loved all of your remarks today. My question is particularly for Professor So. In your presentation and specifically in your paper, you discuss the case Comcast versus National Association of African American Owned Media. And I actually wrote my note topic on that case, and a lot of the students edited it for it to be published later, and I wrote a blog post on it. So I think you don't realize how much you using that case specifically to kind of advocate for your theory resonates with a lot of us. And so I guess I wanted to know, particularly with how you theorize kind of whiteness as contract, how do your theory, you can specifically also tie it within that case if you would like, how does it allow for a more accountability, I guess, within the law school practice, but also within, I guess, the contract of whiteness? How do you think it would push for more accountability for more of a racial equity in those spaces? And secondly, how do you think it allows for the empowerment of voices that have consistently been marginalized? Because I know in your paper you talk about how anti-discrimination law, and when you try to kind of voice complaints and kind of how marginalization has happened and how extraction has happened, and you try to kind of enforce those things through the tools that are already provided, unless there's kind of a smoking gun, a very clear high threshold of the burden of proof that is met, it's unlikely and virtually impossible to kind of get the redress you're kind of looking for. So I think my paper was an attempt, and I hope that someday we could talk about these things further, because I think your work and the work that is burgeoning within St. John's Law really communicates very well with each other. But yeah, I would just kind of like to know your thoughts on those things.
Certainly. Can you hear me? I'm
Yes.
having issues with my mute. Okay, great. Well, thank you for that question. Thank you for and the comments, and I'm really glad to know that you're writing on that topic as well. I think we have to talk about these cases, and really what you're doing when you're talking about a case like Comcast is you are breaking down the silos between private ordering and public law. And what happens is that racial capitalism is able to flourish because it's sort of, we often tell ourselves, and we tell students that private ordering is sort of beyond the realm, largely, not totally, but largely beyond the realm of public law. But then you see ways in which, right, as you see in this case, where public law actually provides a veil, a shroud for private ordering to perpetuate gross inequalities. And to your comment about the smoking gun, we've seen in cases where the smoking gun is not enough because the court will say there's not enough smoking gun, right? And in Comcast, they never said that there wasn't any racial discrimination. They said it's just not enough racial discrimination. Well, as a person who is, vulnerable to racial discrimination, that just reads entirely violent, because, there's this idea that there's a tolerance level for racial discrimination, and if there's just a little bit of it, you can deal. Right. Meanwhile, Mr. Allen, who happens to be very rich, by the way, right? Let's not make a total victim of him, is actively losing money. He's actually losing resources with the tolerable level of discrimination, right, that the Supreme Court has decided exists. So much more so for those who are not like Mr. Allen, a middle class, working class, and poor, right? When they are dealing with, these, everyday, choices that people are making in the private realm that is just business and that is just choice that the government is not supposed to intervene in. So I think just to try to answer your question squarely and succinctly, I think it's really important. I think it does provide accountability to those of us who are teaching commercial law, contracts, property, to not continue to I guess I will say that neoclassical contract and property theory, right, as it is, right, as it was when I was taught it, is violent, right? It is a violent experience to go into a property class and to learn that to be taught that Johnson versus McIntosh is good law, right? That is somehow a valuable way of constructing a republic. And so I think that when we use theories such as whiteness as contract, whiteness as property, the racial contract, and all the other sort of theories that you heard this morning, there's a way for us to present the unvarnished truth about how our theories of property rights, how our theories of bargain and exchange are inherently informed by massacre, genocide, lynching, slavery, sexual violence, and so on and so forth. And that will propel us, hopefully, to seek alternative ways of doing business and of doing government, and for us, doing law.
Thank you all. I see Jeremy with your hand raised. I also, maybe we should do back-to-back questions, and then if they are general questions rather than specific. So Jeremy can go, and then Ryan can go, and then the panelists can respond as they'd like.
Hello, thank you again for speaking with us today. Sorry I was a little late, so if this question was already addressed, I apologize, you can just kind of ignore it. But My question is how we can put into practice, like pushing back against these kind of baked in theory, dominant theories that are violent as lawyers, rather than just outside of the academy or outside of like academic work. Day-to-day work as lawyers, or especially as younger attorneys, how can we push back against what is violent and what is like baked in already as like attorneys day to day?
And Ryan, if
Want me
you
to-
want to
yeah.
pose your question.
Yeah. How's it going? Thanks for coming. So my question is a little intro too. So voting is held up by many as the way to influence and change this system and is valued as a non-violent means of change, which I just don't believe. Meanwhile, free and fair elections legitimize our violent white supremacist capitalist system. Do you know of any attempts that have been done to tabulate the extent of U.S. kind of hegemonic violence or to explain all the different ways that this system is violent to the people that it oppresses?
Should we just take these in any order, Jay? I guess I can start since I had the luxury of going last time.
Wait. I was like waiting.
Yeah, I probably should not have waited as long as I did. I mean, I think these are two very heavy, important questions. I guess to just address them in order. I mean, I think Jeremy, you're asking how do you put into practice sort of, or how do you go up against theories that are violent and are also so dominant that they're essentially like baked into the institutions that we're all to one degree or another like navigating within. And I guess I go back to the first question that Jay asked about the role of theory. I mean, I do think it's important here to have a theoretical framework that hopefully is dynamic and not rigid, that allows you to sort of identify first and foremost when you are up against a violent hegemonic system that operates sort of silently in some ways. And I go back to something Professor Huck said, which was that I think it is really imperative that we kind of recognize our privilege as attorneys, but also recognize that knowledge is produced from below as much as it's produced from above, even if the knowledge that's produced from below is not necessarily empowered or credited as such. And so it's maybe a bit of a like platitude to say this, but I think it's real, and that is like I think we need to listen to people who are directly impacted by these systems. I think we need to listen to organizers. I think we need to take our lead from social movements. And I obviously, like, there is a tension there, I think, between, really taking in the knowledge of people who are directly impacted and also not losing your own framework, because you have something to bring to bear on all of this as well. But I do think, I want my answer to sound as messy as I think the problem is. There is not a neat answer for this. And that's my best cut at it. And then I guess, Ryan, I might need you to just, I'm sorry to do this, could you ask your question again? Because I got hung up on the voting part, and then it ended with like destroying capitalist hegemony, and then I got a little bit distracted by that. So if you could just re-ask the question.
Yeah, so there's like just this assumption that voting is nonviolence. We're voting in Joe Biden. It's nonviolence. It's like, are you kidding me? He's gassing Colombians right now. So is there any kind of tabulation that shows just how widespread the violence of this system is, be it, from Flint, Michigan to bombing buses in Yemen. There's just so much violence that is perpetuated by our system. And I really think that if people knew what they were voting for, they wouldn't vote because it's just ridiculous. So that's why I was trying to put it in that context. So just tabulations of violence committed by the US over the course of its, capitalist history. I think you're muted, sorry.
Sorry, I was going to say, and I will say, I don't know that when you say tabulate the violence, I think that certainly there's some like quantifiable way to deal with that question. But I think for probably most of us, the jury's already out. I mean, you read The Black Jacobins by C.L.R. James, and like that's enough to know, if you didn't know already, that our system is intrinsically deeply violent and like hierarchized along racialized lines, and you could look at like various sites around the world if you did want to like tabulate somehow. I think your question about voting is probably one that it's almost too big to take on here, and if there's a matter of like political tactics and strategy that I think like probably like continues to vex the left to some degree. I mean, I'll just say, and then I will like back out because I don't want to monologue too much, that I think certainly Biden continuing like US imperial hegemony, continuing the kind of violent, state violence that I think you're gesturing toward. Also, I think many of us legitimately believed that the threat of, white supremacist authoritarianism that was, I think, authorized by Trump represented, at least like a unique enough threat that, we could vote for Biden without holding our nose. And I think there are, tactical questions around that that have to do with, the nature of the other larger evil, and what you think voting does in relation to sort of building an actual grassroots movement. And I'll kind of leave it at that. I don't really have a definitive answer because I don't like to impose clarity where I myself am not particularly clear.
Thanks, y'all. And I want to recognize we're at time at 11, so if you need to jump off, that's totally fine. If the panelists are able, maybe we could do like a 5-minute extension. And Ron, I see your hand up, but I want to make sure Professor Huck has a chance to respond because we did promise her to talk, ability to talk about social movements and anti-capitalist lawyering. If you would like to add anything, Professor Huck.
Oh, well, Marissa, do you want to also respond to the movement piece? So I'm going to just respond to Ryan. I think what your project suggests sounds like an evidence mapping, and you may be a geographer, legal geographer in the making. So I don't know of that project, but I would definitely encourage you to think about that. In the human rights field, there is actually a whole sort of area of evidence mapping of connecting international human rights to specific practices and whether they're enforced. So there is some background for that. So that's the extent of responding to your second question. On kind of, I don't think I'm going to add too much more than what Professor Whitlow or John has added in terms of really being each context is going to be different. And I think a framework allows you to understand how does inequality, racial and economic, get reproduced. So part of what I talk about in the paper is the reason for introducing racial capitalism as one framework is that it allows students to be able to see other strategies, legal strategies or solutions that they might employ. So just one example, just to concretize it, And I believe, Marissa talks about this in terms of limits of anti-discrimination law and contracts, right? In Section 1981. If we know that just access to the market, a market that's already racially hierarchical, reproduces racial hierarchy, then anti-discrimination laws or unconscionability in those doctrines are not sufficient. And so then the advocates have to think about, well, what might be certain legal strategies to address that? So some examples of the housing discrimination has come up is greater regulation over flipping homes, greater regulation on appraisers, that the real estate market, to some extent, is very much unregulated. And so this idea even that the market is ultimately going to be fair, it's not going to discriminate, sort of challenging that, and then looking at alternate sort of strategies is what I think, if you were sort of on the ground with community-based organizations, most recently, the Excluded Workers Fund, seems like it's passing through the state. One could not imagine, right? I don't think so. If 10 years ago, as someone who works both at the intersection of labor and immigration, to say, oh, we're going to be in a state that, especially with, our current governor, that's going to actually provide any funding to individuals who are undocumented. Although we know, and I think, John's piece or talks about sort of the vulnerabilities of different communities. That came about because immigrant communities were pushing with labor for that effort. And then lawyers assisted in terms of the drafting of that. So I think, again, I couldn't underscore enough listening to directly impacted folks. And most importantly, I think, is where there is a proposal that you think, oh, it's not articulated in law, or you're like, oh, that will never happen. Just don't ever say that. Think about how can you make that happen? And so I think just that's your expertise or your role. I talk specifically about anti-capitalist lawyering because I think there's a lot of literature on movement lawyering, community lawyering, public interest lawyering, and I just wanted to very clearly and transparently locate myself in terms of I don't think racial equality, economic equality is going to be able to fully be realized under a capitalist political economy, just because of my understanding of racial capitalism. And so a lot of the strategies that I'm going to sort of support are going to be more sort of social democratic in nature: universal health care, guaranteed jobs, housing as a human right. So those perspectives are informed in many part by my understanding of racial capitalism. So lawyers are needed in each of those movements and those fights. I think there's an enormous amount of work that can be happened. So, we can go more into the weeds of it offline if you're interested. But I think that if we're really trying to think about how do we build the architecture of a society, or the legal architecture, if you will, of a society that's really truly about liberation and justice, we have a role that we can play in thinking about that. It's not only about law, because ultimately law has its limits, but we do have some role to play there. So I hope that was responsive.
Thank you all. That was great. And Professor Whitlow, I know, has a time constraint, might need to jump off. But I did want to give you first right of refusal, Professor Jackson. So if you've got a comment or response on any of this, and then I promise we will wrap things up.
That's very gracious of you, Jay. But if Professor Whitlow would like to say something before he leaves, and then I could just close, okay. I will I will make a pitch here, and I think this is responsive to a couple of the questions, right, that came up around voting and what Professor Huck is calling evidence mapping, right, and human rights law, and putting some of what we've talked about this morning into practice. And I want to sort of make a pitch for, but also just point out, sort of make, raise awareness around the work that many radical Black feminists have been doing in this space, and continue to do in this space. Now, I actually take a very sort of expansive view of what it means to be Black, right? And I also take a fairly expansive view of who can be a feminist, right? So I won't try to like issue any definitions of who is and who is not here this morning. But what I will say is that, you know, I'll just use voting as an example, because that I thought that question was really interesting. Black women in the United States and sort of wherever modern racial formation has been in effect, so like globally, literally everywhere, have figured out that under capitalism, that under the global institutional order, that there is really no system under that order that works to the benefit of Black women, right? Precisely because they're women and precisely because they're Black. So literally the inverse of whiteness. And so you'll see Black women moving in public spaces, sometimes in ways that appear to be conservative, or more conservative than one would like, but it is actually subaltern movement, right? It is actually utilitarianism. It is actually survivalism. It is actually harm reduction on the way to liberation, right? As a Black feminist myself, I privilege liberation over equality. I have no illusions that under the current US government that there is ever going to be equality, nor do I desire to be equal within an unjust system. What I am looking for is liberation. But as Professor Whitlow pointed out, right, under the Trump administration, it meant more to me as a woman, as an individual, as a mom. It meant more to me to get the current occupant, that then occupant of the White House out, than it did for me to really sort of interrogate, right, the now current president, even though my personal politics may not have neatly aligned with his, right? It's a harm reduction strategy. And so I think it's really important to give respect to that movement and those actions, because while they may not necessarily align with what appears to be progressive politics, it is important to note that even the progressive political movements that exist currently have failed repeatedly to be responsive to Black women's stated desires and needs, and Black women have repeatedly or sort of requested or demanded that those movements name race, that they name Black women, and beyond sort of the elevation of tokens within those political movements, that they actually are responsive to those systems, and we cannot get positive responses there either. So we continue to work with each other to sort of push society along and continue to carry the Republic along on Black feminist backs, even if it results in incrementalism, where we would prefer transformations, right? So I just want to put that out there and to call attention to the ways that work is even happening in legal scholarship now. You know, Professor Allen here at St. John's has some really incredible forthcoming work. And while you know, I don't know that necessarily that she would identify as a feminist or as a radical Black feminist, that work is doing radical Black feminist work in calling out the violence and the pain that Black women, even in the academy, are experiencing as they try to move education forward towards transformative justice. So I just want to sort of lift up the work that Black feminists have been doing and continue to do, and to also sort of just, you know, clarify what I think has been a really unfortunate tension, where you have people who say, you know, the system is all messed up. Why are you guys who are affected the most still operating within the system? It's like, we're not operating within the system. We are using the system to try to move forward, because we already know that the system serves nowhere. So it just we're just trying to get ourselves out of the extreme necropolitical to a place where movement building can continue. And I think that work should be recognized and appreciated for what it is. So I just wanted to say that, and I think, you know, Professor Huck said at the beginning that this work, feminist work, must be anti-racial and must be anti-capitalist. I will say that anti-capitalist work must also be anti-racist and must also be feminist. And I will just sort of close out my remarks with that, thanking you all once again for what has been an incredible morning for me, and I hope for everyone else.
I mean, thank you all. This is has been tremendous, and I really appreciate the effort and time that y'all gave us for this. Um, that is a wrap. I want to thank especially Ron Anaclerico, the journal's editor-in-chief, and Dalar Islam for the managing editor for being so supportive and bringing this together and helping bring this symposium together. I also want to thank our faculty advisors, Professor Rosa Costello and Elaine Chu, who have also been very encouraging and supportive in this. And want to give a special thanks to Kylie Springs, Jaleesa Omala, and Katie O'Brien for specifically helping me organize, prepare, and bring together this event. It could not have happened without all of their help. So appreciate it, everyone. And like I said, this is being recorded, and we will hope to get it up online as soon as possible. But this was excellent. I appreciate everyone.